Good afternoon, everybody. Thank you for joining us today. We're going to cover the FinCEN real estate reporting rule today, and that goes into effect March 1st. So a couple of housekeeping items. There is a Q&A button at the top. Amy's going to be monitoring the Q&As. We are probably going to handle all those at the end if there's time. We've got 62 slides to get through today, so we're going to move quickly, and we will send out a copy of the presentation afterwards. So let's get going. Important legal disclaimer. I am not an attorney and Thoroughbred is not a law firm. We are not giving legal advice, and this is for educational purposes only. Today's focus, this is not about anti-money laundering theory, talking about why FinCEN thinks we need this regulation. That's all behind us at this point, so we're at the implementation stage. We need to know what's reportable, who files it, and what real world scenario. So this is going to be focused on that. If you've seen other presentations, I've seen probably a dozen of them in the past 3 months. A lot of them focus on the theory. So let's talk about what the FinCEN rule is. This is a nationwide, goes into effect March 1st and applies to certain non-finance transactions. This is not the GTO. This is not what we've been living with in New York City. There is no longer a $300,000 threshold, and it's not temporary. This is a permanent regulation. So we've expanded from roughly 60 counties to every county, every municipality in the United States, and even some US territories. So throughout the course of the presentation, we do have a couple of poll questions just so I could see how, what our audience looks like. So Amy, go ahead and send the first poll question. Have you reviewed the FinCEN residential real estate rule in full? All right, so here's the real crux of the presentation. What makes a transaction reportable? There's 4 questions you need to ask yourself on every transaction. Question 1, is this residential real property? Residential real property in the regulation is defined as a 1 to 4 family, a condo or co-op. Those are the easy ones. The ones that are going to be a little bit more nuanced are vacant residential land. And you'll see on your screen, I added a quote from the regulation: land on which the transferee intends to build a structure designed principally for a 1 to 4 family. So we're gonna have to look at that on each vacant transaction. And multi-use, if you've got a storefront with 1, 2, 3, up to 4 apartments, that's going to qualify as residential real estate under the rule. Different reporting rules than what New York City considers residential and commercial for transfer tax purposes, what we consider for the RPT. We have to follow FinCEN's rules. So what isn't covered? Commercial. So if a project is strictly commercial, would not be covered by the rule. Number 2, is one or more of the buyers an entity or trust? Entity or trust includes LLCs, corporations, partnerships, trusts. If all the buyers are natural persons, the transaction won't be reportable. But if one or more of them is any of these and any other crazy entity type you can come up with, LLCs, trusts, and corporations are going to be the ones we see on a regular basis. Question 3, is the transaction non-financed? If the buyer is taking a mortgage from Citibank, Wells, Prosperity Mortgage, an institutional lender that the transaction will not be reportable. However, if they're paying all cash, they're taking a loan with a hard money lender, they're taking a loan from the seller's financing, their family's financing, they're borrowing money off a credit line on another property, those are all going to potentially be reportable. And the 4th criteria, does an exemption apply? I intentionally put the ones on the right, rare exemptions, very small. Those are going to be very rare. No point to go through those all right now. But the ones we are going to see, death, divorce, bankruptcy, court order, those ones we'll see often. And the one big exemption that we'll use a lot, and credit to American Land Title Association for lobbying for this, zero consideration transfer to an estate planning trust. We're going to go through that one in more details. That will be a useful one that we'll see regularly. So let's go into that exemption. So a estate planning trust exemption, it must be for no consideration into a trust, and the transferor is the settlor or grantor alone or with their spouse, and for estate planning purposes. Quoted the regulation there, all elements must be met. So if we're doing that accommodation recording out of your individuals into a trust, and it meets this, we have an affidavit that we'll have on our website and available that it will get an attorney affirmation that all these elements are met, and we will be able to record this without FinCEN reporting. What does no consideration mean? No money, the most obvious, but no debt forgiveness, no value exchange. 0 on the deed alone isn't enough. The substance matters. So this is back to that common scenario we talk about. Husband and wife own a single family home, transfer the property for 0 consideration into a trust that they are the settlers and trustees of. That would be exempt, and we will request that affirmation, which we'll distribute and have on our website. All right, let's talk reporting cascade. So once we determine if a transaction is reportable with those 4 questions, now we need to determine who is responsible. I don't think in New York we're ever going to get past number 3, but number 1 is listed as the settlement agent. Number 2 prepares the closing or settlement statement. Number 3 records the deed. For most transactions, we won't get past there. There's only one reporting person. The cascade decides who that is. When we're looking at number 1 in there, what is a closing or settlement statement? The regulation defines it as the statement of receipts and disbursements prepared for the transferee, that means the buyer, for a transfer of residential real property. In New York practice, the person who prepares the adjustments, calculates the receipts and disbursements, provides the check cut list, is preparing the statement of receipts and disbursements, even if it's done by email and not a formal HUD statement. So let's open up our second poll question. Amy, in your recent all cash closings, who typically prepares the adjustments and check cut list? All right. So who prepares the closing and settlement statement? So this is where some interpretation of the regulation needs to come, because FinCEN hasn't said exactly what all this means. Recently, as of last week, they put another 100 FAQ questions on their website, which we have linked on our website as well. My practical view, in most New York closings, the seller's attorney will sit highest on the reporting cascade because they're the ones performing the closing adjustments, calculating the receipts, giving the check cut list. However, if the buyer's attorney also prepares a closing statement for their client, they may become the reporting person. This was just issued last week, February 13th, and may apply in that scenario. How does the recording cascade take into account split settlement? So if both the buyer's attorney and seller's attorney are preparing a closing statement for their clients, only the closing statement prepared for the buyer would trigger reporting responsibilities. If you determine you're number 1 on the cascade, so again, in my opinion, most of the time that is going to be the seller's attorney. What can you do about it? Well, the regulation does have a provision for designation agreements. Designation agreement must be in writing. It must be per transaction. You cannot do a blanket designation agreement. It must be from one person in the cascade to another person in the cascade, and it must be signed by both the party designating and the party receiving, and retained by both parties for 5 years pursuant to the regulation. You cannot designate outside the cascade. So, as a seller's attorney, if you would wish to have the title agent that's going to be recording the deed, since the title agent is number 3 in that cascade, that will shift the responsibility. There are also third-party vendors out there popping up. As an attorney, you may choose to retain one of those third-party vendors, but know that when you do that, that does not alleviate you of the responsibility. So designation shifts the responsibility. Selecting a third-party vendor off the cascade does not shift responsibility. So what does reportable actually mean? If a transaction is reportable, the following must be included in the report. Information on the property. This is going to be information we generally already have in our title report. The reporting person's information, so who ultimately ended up on the cascade as the person doing the reporting, buyer information, seller information, and payment information. And we'll go through those all in some more detail. Remember, one of the 4 parts of that test is the buyer is an entity. If they're a corporation, an LLC, a partnership, we're going to need their legal name. We're going to need their current street address. We're going to need their EIN number. In addition, we're going to need the beneficial ownership information of that entity. Beneficial owner is anybody who owns 25% or more of the entity or exercises substantial control over the entity. So it's an either or. For each person who meets those criteria, we'll need their full name, their date of birth, their current residential address, their citizenship, and their taxpayer social security number. Substantial control, managing members, senior officers, individuals directing major decisions. So if you've got a managing member who for some reason doesn't own 25%, only owns 10%, they're going to become reportable. So ownership percentage is not the only test. We also need for the person signing on behalf of the entity. So if they designate someone to sign that doesn't meet the criteria of substantial control and doesn't meet the criteria of beneficial ownership, but they've been authorized to sign, we're going to need name, address, date of birth, taxpayer, and the description of the capacity. Beneficial owners are always natural persons. So if your entity is owned by an entity, which is owned by an entity, which is owned by a trust, we need to work through all those layers until we get down to actual natural people who own the entity. All right, so let's switch over to trust. So again, for those of you who have been used to doing the FinCEN GTOs that we've had in place for the last decade, trusts were exempt. Trusts are no longer exempt. So we're going to need the legal name of the trust, the date the trust was executed, the EIN, and whether the trust is revocable. Beneficial owners of a trust are defined as the trustee, any beneficiary with the right to withdraw substantially all of the assets, any grantor or settlor with revocation rights. So again, on your simple trust, husband and wife into husband and wife as trustees of their, marital trust, it's going to be pretty simple. So the more complicated your trust is going to be, the more levels of detail we're going to need. We're going to need name, date of birth, citizenship, tax ID number for all of these individuals. If the buyer triggers reporting, the seller is reported too. This is the one thing that I don't think many people have been paying attention. If the transaction is determined reportable by the buyer being an entity, along with those other three criteria. Once the transaction becomes reportable, the seller's information is reported. If the seller is an individual, pretty simple, name, date of birth, tax ID number, and address. But if the seller is an LLC, we're going to need their legal name, street address, and EIN of the LLC. And if it's a trust, we're going to need that same information, legal name, date of instrument, EIN, and information on each trustee, depending if the trustee is itself an entity or an individual. So not quite as invasive as the information we need from the buyer. We don't get down to the citizenship. We don't, on the LLCs, we don't get down to beneficial owners, but on the trusts we do. This isn't just about who owns the LLC or the beneficial owner of the trust. It's about where the money came from. So in addition to the information on the parties, we're going to need to know information on the total amount paid, the method of payment, the account number from which it came from, the originating financial institution, and the name of the payer. We're all used to getting a wire confirmation. One piece of information that a wire confirmation doesn't have is the account number that that wire came from. So we're going to have an additional level of due diligence where we're going to need the buyer to tell us what account did you wire out of and get that wire, that account number, and report that as well. This cannot be handled at the closing table. I hope you can see already from the amount of information that's collected. If we wait to the closing table to start gathering this information, your closings are going to be delayed. The Thoroughbred, we're going to be doing everything possible to identify these transactions, get the forms into your hand in advance, follow up with you for them, but you need to make sure you're enhancing your procedures in your office to catch these, flag these as well. Of course, there are going to be last minute changes. All of a sudden, a transaction has been set up with financing and the lender is, delayed in getting it. And at the closing, they're going to say, oh, we're going to close cash and we'll refinance next week. Again, if they're an entity, that's going to trigger reporting. When's the filing deadline? It's the later of 30 days after closing or the last day of the month following the closing. So that gives you a window between 30 and 60 days in most cases to complete the filing. However, the reality, all this information needs to be collected prior to, or worst case, at closing. Title agents and underwriters are going to be unwilling to close without the information. There is no provision in the regulation for a partial or incomplete filing. So if I walk away from a closing and I don't have what I need, my liability is accruing, right? I'm sitting there, I have a legal obligation to file this and I don't have the information. I'm not going to put myself in that situation. I can't go to FinCEN and say, I tried, I didn't get it. There is no provision for that. So best practices, this probably goes for both us and for you. Identify entities early, confirm financing early, address designations before closing, and document any exemption. So if we're going to be exempt for any reason, we're going to want. So again, another form we're going to put out is that vacant land. So if you're telling me that no, my client isn't planning to use the vacant land to be improved by a 1 to 4 family, we're going to have an affidavit that says that. All right, let's go through some scenarios. Pretty simple one. An individual selling to an LLC for all cash, and there is no institutional lender. That's going to be reportable. Refinance transaction. So while the regulation is about transfers, what if at the closing for that refinance, they're going to put a deed into the LLC and borrow with a hard money lender? We see that happen. That's going to make the transaction reportable because of that deed. $0 deed into an LLC post-closing. You ask us, hey, a client wants to put this property in their LLC. It's an accommodation recording. It's reportable. No consideration does not equal an exemption in the regulation anymore for an LLC. So we're going to need to give you forms and have them filled out before we can process that accommodation for recording. $0 deed into a trust post-closing for an accommodation recording. This is not going to be reportable if all that exemption criteria we discussed before was met. All right, poll question number 3. If you're highest on the cascade, what do you plan to do? File it yourself, designate to a title company, use a third-party vendor, or you're still deciding? While you answer that, we're going to go through some FAQs that we got here. And we're doing actually pretty good on time, so we should have some time to answer questions. So remember, if you have questions, put them in the Q&A button, and we should have time at the end to answer some questions. All right. If I'm an authorized signer for an LLC, am I reported? Yes. If you sign on behalf of a reportable transferee entity, your identity information is reported. So if your client's giving a resolution to make you as the attorney, the authorized signer at the closing, doesn't make you a beneficial owner, but it does make you reportable. If I prepare the adjustments and check cut list, am I the reporting person? Possibly. The rule defines the reporting person as the first person in the cascade who prepares the statement of receipts and disbursements. In New York, this is often the seller's attorney. Again, this is where the designation agreement we think is going to get used a lot because title agencies are going to be willing to perform this. If I fill out the form on behalf of my client, am I personally reported? No, merely filling out the form does not make you reportable. Individuals are the buyer, the seller, the beneficial owners, and the reporting person in their professional capacity. If my client refuses to provide social security number or beneficial ownership information, what happens? Without complete information, the reporting person can't file, filing deadlines still apply. This will adjourn your closing. So quite simply, if we can't get the information, we're going to be unable to close. Some of these might be a little repetitive, but I want to keep hitting on them. Are $0 accommodation deeds automatically exempt? No, still not exempt, with the exception of those estate planning deeds. Does hard money or seller financing make it reportable? Yes, if the financing is not from a covered institutional lender, the transaction may be reportable. Non-finance under rule does not simply mean there is no loan. The lender must be a covered financial institution. The best way to check this is going to be if the lender has an NMLS number. We also have a form where if we've got lenders that we don't know, like are they hard money, we're going to have lenders or lenders attorneys certify that they have a anti-money laundering program that makes the transaction exempt. Can I designate a third-party filing service? So that's where we need to understand what designation actually means. You can only designate to a third party if they fall within the reporting cascade. Doesn't mean you can't use a vendor outside the cascade, a third-party vendor, but that's not a designation. A designation under the regulation only applies to people on the cascade, and only designation removes your responsibility to file. If you use a third-party vendor, you're still responsible for the actions or inactions of that third-party vendor. Can I designate to quote unquote my title company. Every title agent's favorite phrase, my title company will do that. Well, if you're the seller's attorney on that transaction and you want to designate to the title company you normally use, that title company is not going to be on the reporting cascade because they don't have a role in the transaction and not the one recording the deed or insuring the policy. So again, could use them as a third-party vendor, but will not alleviate you from your responsibility. May designate to a third-party vendor. Again, a little repetitive here, but designation only on the cascade. All right. If I designate a Thoroughbred, what is the fee? We've set our fee at $250 per transaction for designation. Keep in mind, we are only going to accept designation with a written designation agreement and that we have all the information required to complete that filing before we will agree to it. Information must be provided at or prior to closing. We are not going to accept designation and then chase information post-closing. What if I don't want to be a reporting person? Nobody actually wants to be a reporting person. Unfortunately, if you fall highest on the cascade and do not execute a valid designation agreement, you remain the reporting person. The rule does not allow an opt-out. You can't just say, no, I don't want to. That'd be nice. All right, you don't want to prepare a settlement statement. You want Thoroughbred. Can we ask Thoroughbred to prepare the settlement statement? Sure, we do that on occasion, usually for commercial transactions, but our fee to prepare a settlement statement is $1,500 separate and apart from the $250 designation. So can't just say, oh, I don't want to prepare the settlement statement. You do it. We'll do it, but that's a additional service. What if information is incomplete before closing? Reporting can't be filed, deadlines still apply, which is why we're not going to do it. So if we can't have the information, at or before closing, we're going to be unable to accept designation or unable to close the transaction. Our co-op transactions covered. Well, we hinted before that they were. The regulation defines residential real property in a way that includes co-ops, even though they're not real property, they are in the FinCEN definition of residential property. So not exempt because there's no deed. There's the transfer of shares becomes reportable. Who's the reporting person in a co-op transaction? This is one I'm not sure that I have a good answer for yet. There's usually no title company involved in any of the transactions, so it may be the seller's attorney still because of the disbursements. There may be cases where the management agent is responsible. The cascade must be analyzed transaction by transaction, look at who is performing the items on the cascade, and then make a determination. Reasonable reliance. So I mentioned earlier the kudos to Alta for getting in the exemption for the zero consideration trust deeds, estate planning deeds. This was Alta's other big win, was a reasonable reliance answer. The reporting person may reasonably rely on written certifications and representations provided by others. So if your client is going to fill out the form, sign, and say that these are the members, this is the beneficial ownership, these are the trustees, that they're exempt for one reason, we can reasonably rely on it. However, reasonable reliance does not mean blind reliance. If we've got a copy of the operating agreement, which in many cases we already would because we're going to need that for other purposes, for title underwriting, and they fill out the form inconsistently with other information we already know, we can't rely on reasonable reliance. Again, if we have actual knowledge that they're lying or misrepresenting facts, reasonable reliance would not apply. If my client certifies an exemption, am I protected? Properly, make sure you got it properly documented in writing. The reporting person may rely on the certification. Again, cannot ignore obvious inconsistencies or red flags. Now, I made it through 62 slides in record time. A couple of things here on this last slide. You got a QR code. If you scan that QR code with your phone, it's going to take you to tbtitle.com/FinCEN. That's our living, breathing repository of forms and resources. We've got the Alta Sellers Collection Form, the Alta Buyers Collection Form, the designation agreement on there. We also just added the affirmation for the estate planning trust. So we're going to keep adding to that. So keep that website bookmarked, and it'll be a great place to go get forms if you need them. Many of the forms, like the designation agreement, right now it's on our website with blanks. We are in the process of loading most of these forms into our title production software, where we'll be able to email you copies of things partially filled out. I think we'll have most of them loaded by March 1st, but if you've got transactions that are closing in the first couple of days of the month, I know we've got the first couple of days of March where I'm sending people just the blank forms on our website right now. So, Amy, how are we doing with Q&As?
Chris was busy, but he seems happy. I've got a couple. So for Michael Verga, if reportable info includes source of buyer funds, account number, bank, etc., and the buyer's funds are transferred to buyer's attorney's trust account and dispersed by buyer attorney at closing, an idea or what would you require be reported as the source of the funds? The attorney trust account number or the buyer's account where the funds were originally sourced from?
I think it's the buyer's account where it's ultimately from. I don't think FinCEN is looking to have, title company or attorney's account information. They want to know where this money actually came from. And remember, the whole point of this regulation is to fight money laundering. So they want the ultimate source. Another question pop up in the chat, I think.
Yes. Anyone have an idea of what attorneys will charge to handle this for clients?
I don't know. I haven't spoken to any attorneys who are actually planning on doing it. Every attorney I've spoken to plans on designating to the title company. I do believe that's going to be the more common scenario, but it's a service, and if you are providing it, you certainly should be charging for it, just like Thoroughbred Title will be. Any other Q&As or questions in the chat?
Not as of now.
Well, we're going to I'll leave the meeting going for another minute. If you've got a question, pop it into the Q&A now. We will be distributing a copy of the slide deck, recording of this video, so you can use it to train staff. I would consider doing another presentation in maybe a month when we're, a couple weeks into the regulation and starting to see how it does. So if you have an interest in hearing more, like once we've got some real world practicality, just shoot me an email. And again, if there's enough interest, I will put together another presentation.
We got one more question, Eric.
Okay.
Do you see the local title industry widely agreeing to serve as reporter?
Yeah, most title agents that I've spoken to are assuming that we're going to be the ones doing this, even though we don't have to. But I think title agents are all pretty much geared up, assuming this is going to be a service we're, going to be asked to do. So saw something else pop up in the chat.
One more. Is there a FinCEN portal similar to PrEP?
There is a portal similar to PrEP. Might be a stretch because PrEP is pretty well done. We're lucky to live in a county where we've got a great system like PrEP. The FinCEN website is not quite as user friendly, but yes, there is, and I can send you the link to that so you can review and see what's involved with reporting. Barring any further questions, I appreciate how many people were interested in joining this on just 4 days notice, and feel free to reach out to me via email, phone. If there's anything I can do, Amy can do, or Thoroughbred Title can do, we appreciate each and every one of you, appreciate your business, and look forward to making FinCEN as smooth as possible. Bear with us over the first couple transactions as we work on our own internal systems to make sure nothing slips through the crack.
Eric, we did get one more question. If buyers and sellers' attorneys exchange adjustments, who's the top dog?
That's an interesting question. So, that's where you could possibly fall into that split closing scenario that FinCEN put in their FAQs. If the buyers and sellers attorney both qualify as having prepared a settlement statement, that FAQ says it would be the buyer's attorney. Again, very transaction specific. I think as this plays out over the next, month or 2 months, local attorneys in our market are all going to kind of start to agree. Thank you again for your time and interest, and enjoy your day.
Connect with Thoroughbred Title at tbtitle.com. Find us on YouTube, Instagram, Facebook, and LinkedIn. Links are in the first comment.